Welcome to our Curious Amalgam, the weekly podcast brought to you by the Antitrust Law section of the American Bar Association. Our Curious Amalgam explores the fascinating and increasingly overlapping world of competition, consumer protection, data protection, and privacy law. Each week, we bring you leading global experts on the most compelling issues of the day. Enjoy the show.
Hello, and welcome to our Curious Amalgam. I'm Barry Nigro, and today's episode asks, is it time to burst the bubble? Antitrust law in the age of the Polycrisis. We'll be diving into some of the hottest topics raised at the Antitrust Regulation and Next World Order conference held in Brussels. According to the World Economic Forum, the term polycrisis describes the experience of facing multiple economic and geopolitical crises simultaneously. Some argue that an array of problems, such as climate crisis and supply chain challenges, can be addressed through antitrust regulation. In its current form, however, it's unclear whether competition law can support such a radical shift, going from prioritizing efficiency and productivity to promoting broader public interest. Dubbed the Woodstock of Antitrust, Regulation, and the Next World Order, conference participants questioned whether antitrust should limit itself to a consumer welfare approach or instead be leveraged to promote broader economic, environmental, and geopolitical goals. My co-host is Matthew Hall, a partner at McGuire Woods based in London. Matthew, would you like to introduce today's guest?
Thanks, Barry. Our guest today is Dr. Cristina Caffarra. Cristina is a leading competition economist who in 2023 was described as the high priestess of competition by Politico. She set up the European office of Keystone in 2022, and prior to that, for 15 years, ran one of the top 3 economics consultancies in Europe. She is an honorary professor at University College London and co-founder and vice chair of the Competition Research Policy Network at the Centre for Economic Policy Research, CEPR, in London. She obtained her PhD in economics from the University of Oxford. Hello, Cristina, and welcome to the show.
Hey, Matthew and Barry. Thank you so much for having me. I'm delighted.
Thank you very much for coming on. As Barry mentioned in his introduction, our discussion today follows the amazing large conference which you chaired and organized with the Capital Forum in Brussels in January 2024 called Antitrust Regulation and the Next World Order. This is described as a kind of Anti-Davos or Woodstock for economics and antitrust competition law. So could you just introduce us today by telling us about your thinking behind the event and broadly what you were trying to achieve with it?
Yes. And I think we need to do a little bit of a walk back to the arc of history, really. Because this conference is not something that emerged out of nowhere. In fact, as you know well, I've run a major conference in Brussels since at least 2006, so with 15 years, in which the conference was actually named Economic Developments in Competition Law. Incredibly boring. The program for 10 years was a standard diet of discussion on what's new in mergers, Article 102, exegesis of court decision around object and effect, cartels, damages. So there was a diet of pretty standard competition law topics. And it started at a time in the mid-noughts when there was a big push on the part of economists, as you will recall, for what we described as a more economic. We were certainly of the view at the time that we needed to inject more economics, because economics had purpose, had motive, had certainly structure, and there was a lot of idealism at the time. So at the time, we for 10 years or so pursued this view of a conference around economics and competition law. Then I started to see things changing. Already in 2015, I was at a conference in DC, which was a closed doors, and Peter Orszag at the time in the National Economic Council presented some early results on the relationship between concentration and margins. And there were all the big names at the time. Carl Shapiro was in the room, Joe Farrell, Renata Hesse, everyone was there. There was consternation at this finding because the notion was, you mean concentration? These are not proper relevant markets. What are we talking about? Surely your relationship is too broad. It doesn't mean anything. And then we started hearing also a different set of voices that were talking about original animating values of antitrust being distinct from efficiency, consumer welfare. I recall seeing Barry Lynn, at the time a dangerous revolutionary in Brussels in 2017. I invited Lina Khan, who was a law student, to my conference in 2018 because I had a sense that she was onto something. And then I started shifting the conference pretty much around that time. The conference started being sort of, I described it as competition and regulation at a time of upheaval, competition and regulation in disrupted times, then competition and regulation in political economy. And then this year it has become somewhat ambitiously the next world order, both because we are in an election year, which is incredibly salient for multiple jurisdictions. And so what happens this year will be very much essentially shaping the future of a number of places in the world, including, of course, the US, including the Commission, but also Europe, but also elsewhere. And two, because unless one is lived under a stone, one cannot really miss this great big inflection that we are living through. So every sort of few decades, the political economy comes to a big pivot. What was true starts being less true and then is questioned and things change. And so we have had a neoliberal paradigm which has dominated us for the last, for the period between the 80s, 90s and the mid-20s, around 2018. And then things have changed. Things have dramatically changed. Barry mentioned the Polycrisis at the beginning, a term that not everybody likes, but I think it's easy to see what it means. We are in a world of near extinction through illness, war, inflation, all sorts of things that are happening and the planet is cooking. So my contention and my aim with this conference was really very much to say, we cannot continue practicing competition law as if it is a religion, as if it is something like Moses' tablets that was implanted on us in some way at the beginning of Torah and is immanent and it will never change. But we cannot continue party like it's 2007. We need to just absorb these changes in the world, in the way we think about enforcement, and we do enforcement. We'll get to it later, but this doesn't mean, and this is something I resist constantly, that I think the competition law needs to be used to fight multiple other goals. We're not going to use competition law to fight world hunger or planet ailments, but it is something that needs to prevail what we're doing with other tools, and tools needs to be joined up. That's what I was trying to do.
Okay, and I think by those other tools that need to be joined up, you'll get to this, but you're talking about, for example, trade policy and industrial policy, maybe amongst others. You referred there, Cristina, to the original animating values in antitrust. I think it'd be interesting to hear what you mean by those animating values and whether there's a difference maybe here between the US and other jurisdictions in that regard.
So this is something that matters and means a lot to me. I think animating value is an expression that I heard for the first time from Lina, actually, and from Barry. And I, as a European, not being originally exposed to this thinking, started finding this incredibly moving, actually, and incredibly affecting. Americans have got an origin myth that is incredible. So when you look back at the history of antitrust, the US has a past which is incredibly noble. And when people talk about animating value and mention freedom from all masters, liberty, equality, independence, and ultimately democracy, I find that so much more affecting than anything else we've been doing here. Now, you talk about Europe. And of course, in Europe, post the First World War, we had the development of the ordoliberal thinking, as we know, which was close in many of its values, because it was also about individual freedoms and the use of antitrust to constrain the power of corporation and preserve individual freedom. So there was a lot in common, and this is something that Andreas Mundt, chair of the Cartel Office in Germany, keeps reminding me when I refer to American values. There is an essence of it, which is also very true in Europe. And in fact, antitrust in that spirit was developed in part also to resist anti-democratic tendencies, right? So I think there is a common ideal under there. The reason I mention original animating values in the context of the recent changes that have certainly unfolded in the US, as we can see them from Europe, is that there's been, again, as we can see from here, an effort to essentially say that what antitrust had developed into in the last 30, 40 years, in the neoliberal era, post-Reagan, with the insights of the Chicago School, had moved away from that. We all know it. And that's why I talk about the more economic approach. We in Europe absorbed that vision. I recall doing the GE Honeywell case, and that ancient. I was working for GE 2000. The case was blocked, and it created consternation in the US. Because the view was these European regulators, Mario Monti, are blocking a US deal. Haven't they learned anything? And so, as Mario Monti tells the story, there was an effort on the part of the then Bush administration to essentially tell Europeans, you need to really come into the modern world. The stuff you're doing is historic. You need to think about values of consumer welfare, economic efficiency. This is how we do things in the modern world. I was totally fascinated at the time because I was thinking, wow, this stuff has actually got some structure, some method. We have maths. We can apply maths. So that was the first decade of this century in which we in Europe absorbed and adopted enthusiastic, this more economic approach. Then I think things started to go south.
Do you think the EU moved away from the old style, if you like, principles-based approach, which I think even in the EU could be used? You could look at the EU treaties and say, look, competition policy is based on those, and it can cover a whole range of issues, including even plurality and democracy. You think it moved away from that in, say, around 2000? And do you think that was the wrong thing to do, or it was understandable at the time?
It was understandable at the time. We were moving with the times. We were basically witnessing developments in thinking in the US that we adopted and absorbed with a lot of enthusiasm. I think in the end, though, I think what matters for enforcement may not be so much sort of highfalutin statements about what might be or may not be the goal one pursues in an abstract sort of sense. Because I agree with you. When I talk to people, the frequent pushback is, but in Europe, we do allow, in principle, for all of these other things. We care about quality and we care about all sorts of things. Fairness and diversity, these things are all things that we can deal with. So what I think has actually happened, and it's happened to both the US, perhaps in a more extreme form, and to Europe, is that the practice of antitrust has dried up in the sense that we ended up adopting a number of methods, approaches, tests, empirical experiments that, notwithstanding what one may say about the broader landscape, were pretty repetitive, pretty cookie-cutter, a set of tests and benchmarks. We all know what they are. So in antitrust, we had hesitation competitive test. When we had vertical mergers, we had vertical arithmetic. When we had horizontal mergers, we had guppies. And all of that is fine and dandy. And it was something we also adopted in Europe. That no matter what the big picture value you may be saying you pursue are, when what you do is that, you inevitably end up with narrow analysis, narrow markets, narrow remedies, because what is missing is the zooming. This is the missing part. We've all missed the zooming out. We all funnel into what's the relevant market, what's the market shares, what's the guppy, what's the vertical arithmetic, how can I remedy this? And as we have learned, markets have concentrated serially over time, notwithstanding the fact that in a particular relevant market, you might not be above a certain threshold, but industries have been concentrating. And I'm not escaping my responsibility, involved in the serial concentration of the chemical industry. The chemical industry in Europe was dispersed and fragmented. It's become concentrated. There were aggregators, firms like Ineos that bought every asset in sight, pharmaceutical, agro-pharma, all sorts of industries. Big picture have become more concentrated. But we looked at every single little merger, every single little market one by one. And then we adopted mergers remedies that really didn't restore competition. We are where we are. And that's true in the US, it's true in Europe. Doesn't matter that in principle we could include values like quality in the analysis. We don't. We just did what we did because we had the data we had, because we could look under the lamppost with the data we had, because the accepted methods was that. And I'm not saying it's worthless. I find it very uninventive now. If you look at merger analysis now, it's incredibly repetitive and incredibly cookie cutting. There's no innovation. And that's why I think the stepping back is the zooming out and the questioning of what is the outcome in terms of what we are seeing around us. It's markets that are more and more concentrated, and that's a problem.
You've talked a few times about zooming out, and you've mentioned a broad range of values. Just how, as a practical matter, how do the enforcement agencies responsible for antitrust and competition enforcement, how do they take those into account? Which values matter, and do they trump competition? Because some of the values that you're mentioning don't obviously fit into the competition box.
I think there is a misunderstanding, Barry, because the values I mentioned, yes, are values of fairness and equality, and these are values that I think we have somewhat downgraded in antitrust, which I think we should upgrade again. To give an example, discrimination. Discrimination is in the treaty. It's an object. Non-discrimination is something that European law certainly has pursued, except that we economists are convinced that the world that discrimination is mostly pro-competitive because it expands output. I've been in so many cases in which you mean discrimination is not a problem. It expands output. It is pro-competitive. It is now being questioned. It was a very convenient, what I call exculpatory narrative, that we can defend almost anything on earth with a pro-competitive, efficient narrative. I don't believe that's credible anymore. So when you talk about other values, yes, some are there, like fairness in the relationship between parties. We now, I think, generally question whether discrimination is something we should just presumptively take as acceptable. In mergers, I still worry massively about market power. People say things like, oh, when I'm looking at a merger, I ask myself whether the market power will increase, not whether it's good or bad for democracy. That is a pretty dumb push, frankly, because no one is suggesting that one should ask the question whether a merger is good or bad for democracy. The question is, the concentration of assets systematically across multiple industries creates a concentration of economic power that in turn creates a concentration of political power or an impact on political power that can be a threat to democracy. So these are the passages that Warren goes through. When I'm thinking about a merger, I'm still thinking about, market power. I'm an economist. I don't really think I should just think about something else. However, I also think we should think about whether a merger is in an industry which has become gradually more concentrated, whether we are adopting remedies that stand any chance of restoring that. History matters. Remedies have been shown not to restore competition. We've been too worried about type 1 error. Type 1 error has been the bane of economists for decades because, of course, we've been all saying, what if we commit a type 1 error? What if we block something that was actually not so bad? And so who is going to die? Say that instead of blocking 3 mergers a year, you block 4. Is that going to really undermine incentives for innovation and creativity across the place? I don't believe it. So I think, for example, the balance between type 1 and type 2 error cost of enforcement has changed in modern times. I think what has changed is certainly the notion that we should be concerned about that. The understanding we have about what drives innovation and mergers is broader. But there's also a better understanding, I think, of the pathologies of market power. We have market power relating to things like even inflation. Some don't believe it, but some do. There is some relationship there. So we have pathologies that are associated with it. And are presumptions so bad? At the beginning of my career, I know that Andreas Mundt, again of the Cattell office, laughs and says, Cristina, 15 years ago, you used to tell me I was a fossil because I was doing presumptions, and now you think we should do presumptions yourself. Well, guess what? I am in favor of some increase in presumptions. And not that everything goes, or almost anything goes. And I think it's legitimate to rethink what we used to believe in the light of outcomes. It's not like one wakes up one morning and had an epiphany, but outcomes drive what we see. I don't know if you happen to see it, but there was an incredible article by Angus Deaton. Angus Deaton is a Nobel Prize, and he wrote this article, Rethinking My Economics, in the blog of the International Monetary Forum, that well-known left-wing organ. And he's basically written there that he's a Nobel Prize, but he thinks that much of what he's been thinking and he's been pursuing for the last 40 years is now something that troubles him. And he goes through, for example, the notion of power. The first sort of paragraph is in his article is power. We economists have completely underestimated and understated the role that power plays in setting prices, setting commercial conditions with partners. We've absolutely maxed out on efficiency. And he has a wonderful turn of phrase. He says, we've focused on efficiency, arguing that fairness and redistribution were the task of others, such as political decision makers. But because these never come to the party, when you're left just with pursuing efficiency, you're effectively, in many cases, allowing for plunder, because we're looking at upward redistribution. So redistribution of wealth from the bottom to the top. And Angus Deaton saying these things is incredibly powerful to me.
You know, that is an interesting article. I have seen that. We'll put that on our website with this episode, Cristina. You referred there to outcomes. Presumably you're not questioning the concept that competitive markets, broadly speaking, achieve the best outcomes. And maybe I just want to, as a sub kind of question there, I know you've talked about supply chain failures being something that should be looked at in this context, but haven't supply chains in recent times, despite pandemic, war, blockades in the Red Sea, shooting in the Red Sea, etc., actually proven to be incredibly resilient? And how has that come about if it isn't just companies competing and producing their own alternative routes and just sorting it out themselves, essentially.
But Matthew, I don't think there's any daylight between us on competition being the regime that I favor. I'm certainly not in favor of any other regime. If markets are competitive and they are sufficiently fragmented, then one would hope that this brings about, about the best outcome. Competition can also be cruel when it comes to fairness. One needs to be a little careful, but yes, I'm totally in favor of competitive markets. The problem is we have allowed concentration to go far in a number of markets and competitive markets to become more concentrated over time. You talk about resilience. I'm not saying anything particularly original here, but I think there is an entire body of thinking that is looked at what's happened with the pandemic, and many of the problems of supply chains were attributed to concentration of markets that essentially offshored some production, reduced the breadth and made the chain more brittle, because one linking the chain goes down, the chain is down. If you have competition or more levels of the chain, then you can diversify. So absolutely, competition, diversification are values that I totally uphold. The problem there with resilience appears to be that we went the other way, that in the name of efficiency pursuits, in the name of efficiency for its own sake, we have favored the lower cost, the lower price, and that has dried up the chains into very narrow, brittle beings. So fundamentally, I don't think we are disagreeing in any sense. I'm disagreeing slightly with the diagnosis of the outcome, which is, I think, reality in the last 5 years has shown us that we have real significant points of weakness in this chain that associate in many cases, not with competition, but with monopolies, but with restriction of sort of choice. And so that's really where it's at.
Picking up on one of Barry's earlier questions, in particular, seems to me that a lot of your message here is really aimed at the regulators. We have a lot of listeners here who are private practice lawyers and economists. I know you've criticized them, maybe a bit tongue-in-cheek, for cookie-cutter economics and submissions and just carrying on, but are they just acting in their clients' interests? And is this message at all relevant for the private practice practitioner who's just out there doing his or her job?
People cannot operate in a vacuum, right? At my conference, when I've been increasingly putting out there messages that are progressive, then clients, big tech companies too, have said, Cristina, your conference makes us uncomfortable, but we need to come to hear what people say, what regulators are saying. We need to understand what the language is. And let me be clear, I completely understand that lawyers and practitioners have got a job to do. I actually think there's nothing wrong with that. One is in the business of protecting the client's interest, and I get it. I'm less lenient with economists because we do not have the same deontology. We are not charged with defending our client as a professional obligation. We're in principle experts, right? And so in principle, we should be saying things that are as close to what is true as possible. So while one understands client interest, I think economists have gone too far, and I'm really not forgiving of that in becoming advocates. So I make a distinction. Lawyers are advocates. That's your job. And you do what you gotta do. I don't resent that. But economists, if they want to swan around and pretend that they're experts, then they need to just be questioning whether what they say is really just being a mouthpiece for the client and being advocates. And I see a lot of that. And as this has been one of the things that has disturbed me most, made me pretty much abandon much of consulting because I find that disturbing. Of course, when it comes to what I say, do I say it for, I say what I think. I don't say it for any particular constituency I don't have any commercial interest for sure in what I think, because if anything, people are scared of me and they couldn't give me jobs in consulting, which is just fine. But the regulators have an incredible task, which is really to pursue this. I regard it as a privilege to be able to actually pursue things that are in the interest of people. And
well, I'm very pleased that you've let the lawyers off, Cristina.
It's okay. It's your job.
Both Barry and I are very pleased that you distinguish between economists and lawyers here. Thank you very much for that. I just wanted to ask as well, looking at recent EU cases in antitrust, do you think that the EU is going after the wrong cases at the moment, and they're just doing some which, bearing in mind your thesis here, have really taken a lot of time, effort, money, etc., and really have added no particular value and are a bit of a waste of time?
Look, the history of European enforcement, particularly in digital, is one of failure. We know this. We know that antitrust is not delivered. And that is in part the function of weak remedies, which is, in my mind, the issue in the Google cases. Whether good remedies can be found is a very difficult matter, but we pursued in Europe. We had Google Android, we had Google Shopping, we had Google AdSense. Nothing came of it because the remedies were useless. It then is the case that other digital cases have been pursued. Amazon and Spotify, and there's the ongoing case of AdTech, and there is a Meta case. These cases have taken forever. That's the problem. They've taken far too long. And the real criticism I would have, an observation I would have, is that we know that the issue with many of these platforms is that they are extractive, that they exploit the relationship with their dependents. And so the theory of harm, if they have to have any bite, need to focus on that. What has happened, certainly in the Amazon case, the Apple Spotify case, is years were wasted trying to construct an exclusionary case. Why? Because we're all in love with the Microsoft case, because the court has approved of the Microsoft case. Android was a great case because it was another Microsoft case. And so we know that the court will stick with us and will go with that. Doing exploitative abuse cases for the Commission has been very scary. Not for France, as I learned, and I see France does it more regularly. Germany to some extent, but in Brussels, exploitation has not really been very much used. So the Amazon cases, the buy box, the data cases I did were exclusionary cases to begin with. And one was scratching one's head, thinking, where is the exclusion here exactly? What's the exclusion problem? Who is being excluded? Ditto with Apple. Apple Spotify is a case also I worked on. And again, the question is not exclusion. No one is excluded from the App Store. The question is whether the terms of being on the App Store are problematic or not. But that's an exploitation case, not an exclusion case. So everything has been very much pursued in the wrong way, to my mind. And now the Amazon case was settled. The Apple case very late pivoted into a fairness exploitative thing. But you wonder, what does that do? What does that do at a time when the DMA is in any event coming over? So I think that the problem we have with Joe in particular in Europe is that we don't have enough cases. They're all dormant for far too long. There is the Microsoft Teams case, which has been going for 5 years. Where is that case? Who knows? What is the theory of harm? Who knows? So all of this happens in this kind of suspended animation. And therefore, we don't see much. We don't have much to show for it, frankly. We have nothing to show for it. The DMA is the solution. We will see what happens. That's just in digital.
We could probably talk about these cases forever, Cristina. I just wanted to ask one more substantive question here, which essentially picks up on a comment going back to the conference. It's been well reported in the press, a comment about a side dish. Can you take us through your view on that, what it was about briefly, and also Do you think it shows that the European Commission doesn't get all of this? Is there a problem there?
The way in which I had framed the conference and the way in which I framed the discussion with Olivier, I'd given him notice that I wanted to talk about these three topics, industrial policy, and then other ways in which we need, in my view, to join the dots between competition and other tools. Because my personal sense is that it's great that we have the DMA, it's great, we are enforcing it, but it is the case that in Europe we have deep structural problems that America doesn't have, the US don't have. The US economy is trucking, whether you see it or not, but jobs are being added, GDP is high. We have massive problems of competitiveness, falling productivity. And the DMA, good as it is not going to put points on GDP. So I'm just questioning, what are we going to do in an election year to think in a connected way about all the other things that we need to think about? For example, industrial policy. Is it just state aid? Is the role of antitrust in industrial policy just to be a policeman of the national champions? Or is there a broader, more profound sort of thinking that can be usefully included in, for example, the way in which Europe needs to make major investment into productive assets in the future? We are in a hole as a continent. We need to come out of it in some way. We need connected decision-making around big investment that we need to make. So what's the role of antitrust in all of this? I see decisions that say, we've approved the state aid, 100 million for Sardinian farmers for the war in Ukraine. Say, okay, fine, that's great. But what does that do? Is that what state aid does? So trade, similarly, we have a huge rethinking of trade policy in the US, which is controversial. I'm not pretending it is not, but there is a big rethink about what the values of trade ought to be. In a world in which we're fighting anti-monopoly, we're fighting monopolies at home, but then we're exporting monopoly values through trade rules abroad. So that is a big discussion to be had. And so I was questioning, what was the broader vision? I think Olivier was intending to say, look, these are big decisions on industrial investment, on trade, in which competition has a limited role to play. And that may well be his view. I think many reacted at the conference with great alarm. That was his view, because not only there was a sort of the room lit up with Twitter when he said that, but Becca Slaughter, just in the panel after him, said, with due respect, I disagree, because of course in the US, you have this, at least this all of government approach, as we understand it here, in which there is at least an invitation to the various departments to try and move together. I'm not saying that Europe doesn't do it. What I found, though, is at my conference, the language and energy of the US regulator was remarkable. They were all fluid, fluent, assertive, affirmative. They really were impressive.
They sure were, Cristina. I was there, so I can personally attest to that. And just to confirm, you've been referring to Olivier Gerson, the senior permanent staff member at the DG Comp of the European Commission. And I'm not going to attempt, of course, to comment for him, but I know he did make some further comments to GCR in relation to his side dish issue. So maybe we'll just leave it at that.
I understand what he was trying to say, but I'm just saying that in the circumstances, it didn't come out right. That's all.
Before we move to the final segment here, Cristina, have you organized, or are you starting to organize Next World Order 2 for 2025 in Brussels?
You bet. I'd love to. It all depends, however, on how, of course, the elections go in the US. So we need to see what happens there. And that's not going to be known before this sort of end of the year. And then we have an election in Brussels where we don't know who's going to be in place similarly, pretty much in the key roles until much later in the year. So I certainly will do it again, but it won't be January. It probably will be slightly later in the year, something like March, April.
We look forward to hearing about that. So, Cristina, during our closing segment, we typically like to learn a little bit more about our guest. And so, along those lines, tell us something about yourself that we would not know if we knew you only in a professional setting.
Okay. I own a ranch in Texas. How's that?
I did not know that.
I bought recently a ranch in Texas, which is 500 acres in Bosque County. My next door neighbor is none other than Taylor Sheridan, who has done Yellowstone. So yeah, if you didn't know me, you don't know that I have a complete passion, cowboy life. I ride. I love to spend my holidays in the Southwest between Texas, Arizona, Utah, and New Mexico. And that's my favorite part of the world.
That's really interesting. So we have one last fun question for you. It's a game we call the Curious Hat. And the game is simple. The best part is you can't lose. I'm going to pull from our virtual hat a random question, and you should answer with the first thing that comes to mind. Are you ready?
Yes.
And now it's time for the Curious Hat.
Okay, here we go. If you were given $50,000 on the condition that you had to spend all of it in 1 hour, what would you buy?
You don't need to know me very well to know that I'll blow it on clothes and fashion.
Oh, I thought you were going to say a ranch.
You can buy a few cows and a few horses,
Okay.
but that's taken care of. I think I know how to spend it in handbags.
Okay, there's a handbag merger happening now. We'll see about that. Anyway, that sounds fun, and thank you so much for joining Matthew and me today. And to our audience, we look forward to seeing you here next week on Our Curious Amalgam.
Thank you for listening to this week's episode of Our Curious Amalgam, a competition, consumer protection, data protection, and privacy law podcast. It is produced and shared around the globe by ABA's Antitrust Law Section. The opinions expressed by the participants in this podcast are their own and do not necessarily represent their employer or other organizations. If you like what you heard or would like to become a member of the American Bar Association, please check out what the Antitrust section has to offer at ambar.org/antitrust. You can learn more about our podcast at ourcuriousamalgam.com. If you have comments, suggestions, or podcast ideas, please reach out to us at podcast@ourcuriousamalgam.com. Until next time, thank you for listening.